Ladies and gentlemen, please take your seats. Session 1 of the conference is about to begin. As we have previously announced, simultaneous interpretation in English, Cantonese, and Putonghua is available. Participants joining the conference virtually may choose your preferred language from the interpretation icon at the bottom of the Zoom platform. As for the guests attending in person, you may collect the headset at the help desk at the entrance if needed. We would also like to request your kind cooperation to switch all your electronic and mobile devices to silent or vibration mode. Thank you.
Ladies and gentlemen, distinguished guests, I'm delighted and honored to be moderating this first session entitled, What Kind of Metaverse Do We Wish to Build and Share Along the Belt and Road? The Belt and Road represents a multi-jurisdictional environment for trade, services, infrastructure development, finance, and exchange of cultures on a physical plane. The metaverse could refer to both current and future integrated digital platforms focused on virtual and augmented reality, or possibly more, limited only by our imagination, design, and most importantly, implementation. The metaverse represents an opportunity to enhance these elements in the virtual world, mixed world, and possibly experience them in an augmented reality. The metaverse provides an opportunity for creation of blue ocean strategies for development of products and services. One may ask the question, why is this an opportunity? One answer could be because the metaverse is still in its infancy with a huge potential for development. The paper is blank. What we draw is what we get. How it develops further and depends on innovations in technology, mathematics, science, and most importantly, application in the real world along the Belt and Road. Ultimately, innovation is going to be the key to Blue Ocean strategy. We have 3 distinguished speakers today, each with unique and substantial experience in the field of technology and innovation. Mr. Duncan Chew, a member of Technology and Innovation, Legislative Council member of the Hong Kong SAR, is committed to the development of InnoTech. He will begin by looking at the legislative changes in Hong Kong aimed at addressing the protection of IP rights in the face of technological development such as cryptocurrency, copyright, NFT, Web3. Next, we'll have Jamie Kwok. Jamie is Head of Legal Animoca Brands Limited, in charge of the legal team and advising on commercial and investment transactions. Jamie will give us an overview of the metaverse and what it means as to ownership, property ownership, freedom, equality, and interoperability within the metaverse along the Belt and Road. Leading us to the question and answer session will be Donata Stronik-Skilrud, an attorney licensed in Illinois and a certified information privacy professional. She is president and legal engineer behind Termagodon LLC, which is a SaaS provider. Donata will give us examples with reference to US and EU experience on issues of privacy and security. So please, take out your pens and prepare to jot down your questions for the questions and answer session. May I now invite Duncan to kick off this session with talk. Thank you, Duncan.
Thank you, Mr. Amrali Nasir, MXJP, our Vice President of the Law Society of Hong Kong and Chairman of the InnoTech Committee. So now we have come to session 1 of the conference. There will be a Q&A session, as Vice President has said, after speakers sharing for each session. We welcome guests on site to write down any question you have for the speakers on the question slip in the conference folder and hand it over to our colleagues. The participants joining by Zoom may type in your questions in the Q&A box during or after the presentation. So now, without further ado, I now invite the Honourable Duncan Chew, Member of the Technology and Innovation Legislative Council of the Hong Kong Special Administrative Region of the People's Republic of China, to address the audience, please. Thank you.
Thank you, MC. Thank you, Amir. Good morning, everyone. My honor to be at the Legal Week 2022 to share with you my thoughts on Metaverse, Belt and Road. It's actually a bit contradicting to limit Metaverse in Belt and Road, but I guess our other speakers will go into that part. Just a heads up, as a tech investor for 20 years, I'm not trained in practice in law. So, we're in front of all these legal experts here. It'd be challenging for me. But I mean, as a legislator, I have to definitely go through some of my thoughts on the legislation side, because I think technology and legislation has to go hand in hand. And, tech always, in terms of innovations, go faster than legal and legislation work. So how to play catch up, I think, is one thing we have to work on. I want to go with an overview of what happened in Hong Kong in terms of legislation. So if we look at the scene in Hong Kong, before we go into Metaverse and the definition of Metaverse, I think the other experts are going to share with you. But we've gone through the stage that a few years back we think tech can do anything, right? So innovation actually not replaced, but leading many even professional guidelines and setting up of regulations. So a lot of the tech company, tech moguls, they're trying to providing services and try to change or disrupt the way you govern a business or professions. And I think this actually cooled down a bit, with the, what happens to end financials and stuff. There are areas that we think professionalism and regulations also played a big part in how tech has been employed. So I think the balance between legislation and the innovation, where legislation will not hinder the development of a technology, and how to get the balance while innovation will not lead to disruption of public wealth and other creation of crime. So I think that's a good balance, and we have to catch up on many of these issues. So if you look at these, we have several previous existing laws or regulations that we have. If you look at the blue boxes, which govern many of the virtual and real world today, where we are in discussion of the copyright amendment bill, which took us like 14 years. I just consulted David, or possibly more, to do the amendment, where we raised the topic in 2009, and we're going through the process now, which involved the copyrights and a lot about the copyrights being transmitted online or created online. And that will lead to some other questions we might go into later, including the AI-generated content, where will be the next generation of copyright discussions that we're going to have. And then we have the all-encompassing, the access to computer with criminal or dishonest intent, where it's very commonly used now with a lot of the cybercrime today. And whether that is up to date, and the way we call it access to computer, is that still relevant? Because a lot of the virtual crime or cybercrime today doesn't really need to have physical access to a computer. Of course, there has been cases in court that you don't have to physically access the computer. You can still be charged. But I mean, the way we call it, whether that is still update with the current trend is one thing. So that's why we have the Law Reform Committee has just done the consultation about 5 cybercrime jurisdiction issue, and that is in progress. And in terms of PDPO, there has been some discussion whether the current one is enough, or in terms of offences and the penalty related to offences. So I raised in January in LegCo about considering a all-encompassing cybersecurity law or data security law, where, GDPR has been up and running in Europe for like 5 years. And of course, mainland China has a lot of different laws and regulations regulating online security and data use. So I think with the current expansion in the data, not just created in metaverse, but in internet and other related area, it's about time we have to revisit whether we have enough legislations, enough laws and regulations in terms of protecting data online. And another thing about virtual assets in metaverse, of course, it started from possibly digital twin idea, and now it's all encompassing, including VR, gaming, including creation of tokens and virtual properties. That's the metaverse development. And in that, a big part is virtual assets, where it will be created in metaverse, and whether it's in the form of virtual materials or tokens or even cryptos. So I think that how we deal with that, whether we have enough regulations to regulate that, what is the vetting mechanism, I think these are all behind the reason we are now going through the anti-money laundering, the AML and counter-terrorist financing bill. We've done second reading debate already, and that will include the issuing of the virtual asset service provider license, whereas we actually have two issuer getting the license already, but the VASP will further clarify, how digital assets in Hong Kong through platforms can be traded and the vetting process, etc. And also in the FinTech Week 2 weeks ago, I think the government also announced their policy statement. I think that attract a lot of attention from the tech innovation sector, especially people in the metaverse or dealing with virtual assets. The policy statement on development of virtual assets in Hong Kong, likely, I think the consultation will be out in the next 2-3 months. And with that, we will make amendment to the SFO or the regulations, and that will deal with the public involvement or retail investment in virtual assets. And definitely, one more thing is about the crowdfunding. I've been advocating for crowdfunding legislation in Hong Kong since 2016. I think it didn't get considered a few years back, and now the government also considering crowdfunding discussions possibly next year. So these are all regulations or laws that we are having discussions on that will contribute to the development of the virtual assets, digital assets, and even metaverse world. I think I only have 5 minutes more. I can only go through it a little bit more on what I think. I think, we all heard about NFT, which is one part of the metaverse assets being created. So I'm sure we will have other elaborations. But, the NFT go through the, I wouldn't say boom and bust, but a boom and correction for the last years, and use case and imaginations are unlimited. But then when you look into our tech, people saying the Gartner hype cycle, it perfectly followed the Gartner hype cycle, and now it's going on the down slope. And definitely we have to look for more use cases. Possibly Animoca is one of the contributor, and then it become real a mass commercially viable thing. But I think NFT is going to be a lot of discussions. We'll attract a lot of discussions onwards. But I would say category, if I want to categorize how we use NFT, one, these all need legal backings. One is a very good use people first explore as a track and trace system. You tag it with, let's say, an art piece, how it's been traded, the history of the buy and sell, etc. But whether, tagging a digital signature with art piece, whether that's the real art piece or not, that also needs some, legal backing on it. And the other thing is sort of like tokenize an asset, that also you have to go back to the authenticity and the right of the owner during the tokenization process. That also need law backings on that. And the third thing is creation of virtual assets, that the whole thing is being created and tracked virtually, namely, these BAYC or CryptoPunks, a very famous example. But sometimes they also contributed to an online asset, virtual asset, giving you a real life property ownership. So let's say if you own the Boring 8, the Bored Ape, you also have the right to make physical product of that monkey, right? So the physical product, can you trade it? And when you sell the virtual product, does it also go with the physical right of creating of the property right of that T-shirt with that face, right? So I think these are all things we have to look into, whether in physical world, even the virtual side, we have blockchain, we have trace and track function of all the record of that being traded. But the transaction of physical world, how it governs, it still needs some contractual relationship. And one also very popular use is the use of NFT as a service or membership. Let's say you buy it for virtual, you buy the NFT coin and then you have next 3 years access to concert of an artist. So whether you have the right to sell the concert right of an artist, that also need a contractual backing. So these are things we have to look into, whether the trade description ordinance is enough to govern, what NFT has to create, and definitely there are more options. And there's a case that I want to draw your attention if you haven't, the High Court case in Singapore, Janesh Rakuma versus an unknown person, where it's just a few months back, and the judgment make it clear that the court said a smart contract is a contract. They admitted a smart contract being dealt or performed online between two, a loan giver and the loan drawer. That is a successful, that is a real contract. The whole thing being done online between the two persons without a lawyer in between. That would be a contract. That's one thing. Second thing, it also confirmed NFT is a property. So that's the definition you can draw from this case. And I won't go into all this detail, but there are other things that we have to be concerned. Oh, that's my old PPT. With the new one, actually, I input there are other things we have to be concerned, like there'll be more and more data or created online through AI. And there's another case which is just last month, I think can draw to your attention, is people sue GitHub and Microsoft, saying that GitHub provides some open source source code, and they help programmer to create, new source code with the OpenAI provided by Microsoft. And they're saying that Microsoft and GitHub is using open source code without proper permissions. So these are new cases we're going to see a lot in terms of AI generate content, whether they're using even open source code to create new source code. Is that, do you have the legal right to do that through AI engines? So I'm sure my time's up. We're going to have a lot more discussions on these, but I think tech innovations will only get more advanced day to day and day by day. And I think legislations and legal work has to go hand in hand to cope with the new development and to make Hong Kong as a IP collection center, tech innovation hubs, and with the metaverse development. Okay, thank you. I think my time is up. Thank you.
Thank you very much, Duncan. Now I invite Ms. Jamie Kwok to present her.
Hi, everyone. My name is Jamie Kwok. I am Head of Legal at Animoca Brands. So what is the metaverse? When we talk about the metaverse, one conjures up a digital world where you would roam around in your avatar and explore the new worlds that people create, either to tour an art gallery or partake in a fashion parade or watch a sports event or even attend a wedding. So immediately, almost people think about the sandbox or the Second Life. And the sandbox and the Second Life are indeed metaverses. They are decentralized metaverses, to be exact. Animoca Brands owned Sandbox. So what does the metaverse mean to Animoca Brands? To us, metaverse means more than just a digital world. It is about digital property ownership. If you think about it, countries which allow property ownership tend to prosper and do better than countries that don't allow property ownership. And this is equally true in Web3. Digital property ownership to us is about owning non-fungible tokens, NFTs. And what NFTs are is that they're non-fungible because they're unique, they're irreplaceable, they cannot be interchanged, they are scarce, and they have a traits that is unique to that token itself. So what does it mean to have digital property ownership? Digital property ownership is the key to freedom. And freedom takes the form of data ownership, financial equality, access to capital formation, free market, and even decentralized autonomous organisation, and much more. But today I've only got time to talk about these few. So data ownership. So each time we use like Apple or Facebook or Google, we create contents. But these contents are not owned by us. They're actually owned by the platforms that we use. And these platforms, they take our contents and then they sell it and make billions of dollars of profit. And if we all know that the time in which we spend on these platforms are monetized by these platforms to their benefit, and it's not shared with us, we will want to take more control of our own data and of our own contents. Blockchain technology allows this to happen. So your time can be translated into NFTs and you can monetize that yourself. All things that are contents can become digital assets. We can create contents on the blockchain and then we can monetize itself, set the price, and decide on which platform we wish to sell them. But we will retain the copyright in these content ourselves. And in turn, this allows us to take in royalties from secondary transactions and so forth. Financial equality. So in a world where the ability to generate income is not evenly distributed, having digital property ownership changes this. An example is a block game called Axie Infinity, which is owned by Animoca Brands. For those unfamiliar with the game, it's about minting, breeding, and collecting pets called Axies. And then you can use them for battle and you can use them to build kingdoms. Axie Infinity was able to onboard millions of people. So prior to the crypto winter, the statistics showed that about 35% of the people playing Axie were from the Philippines. This game created millions of employment for people in the Philippines. For some of those people, they couldn't even get a credit card or even open a bank account, but they were able to open a crypto wallet. And with this wallet, it allows them to transact on their time and get the most value out of it. So they were able to buy Axies or even borrow Axies or lend Axies. Some people even started a business of loaning Axies for those who could not afford to buy the initial fee. This is all made possible because of digital property ownership. Access to capital formation. Having digital property ownership opens a different form of capital, access to capital. One of the original applications of NFTs, as we all know, is art NFT. So this allows artists to create digital arts and then sell them on the blockchain. And then they were able to also get royalties from secondary sales and so on. So this form of technology gave the artists an additional form of income, so it allows them to continue creating. So recently, Animoca Brands bought a company called TinyTap, which is based in Israel. This is a Web2 company which is basically a platform that allows teachers to create educational games for children. So after the acquisition, together with TinyTap, we released an innovative NFT called Co-Publisher NFT. So this NFT allows people who buy the NFT to help, publish or promote the course, which in turn gave the teachers additional source of income. And through blockchain, this has allowed or encouraged more development of educational courses for children. The Co-Publisher NFT was auctioned last week, and it closed and netted about 140 ETH, which was about $228,000 at that time, for courses created by 6 teachers. Free market. So as we all know, the blockchain is all transparent, which allows for a free and fair and open market. This means you can trace the creators to the initial buyer, to the subsequent buyer, and so on. You can even trace the payments that's been made and how much it has been paid. You can basically follow the transactions from the mint of the NFT. These are all recorded on the ledger. And so to speak, it is immutable. So this completely shifts the mindset of Web2 companies which take our content and use it for their own benefit, but keep it all secret, to information being open and accessible. So with this, you can now determine the transaction activities, which allows you to decide which products you can sell and how to market these products. DAOs, which I want to touch on quickly. As you all know, that crypto doesn't sleep. It is faceless and it is borderless. Most people use a pseudonym in the metaverse. And whilst people argue this obscures identity, to me, it opens up communications. It allows people to get together and talk to each other, regardless of your background, your age, your gender, even your profession. This is quite powerful to me personally, because it allows people to come and share information on an open platform, which is barrierless and borderless. So the next step that sort of evolved from that is DAOs, which are decentralized autonomous organization. So what it is people holding tokens coming together to form a community or an organization. And this organization make decisions through voting. So instead of in a Web2 company where all the decision making is centralized on a small group of people representing the board of directors, you have decisions made by the community who are holding the tokens. So governance is evenly distributed. So what is the future of the metaverse? Digital property ownership will continue to scale, will continue to grow in adoption, in scale and application. This year, we have been in talks with a lot of Web2 companies who wish to enter the metaverse. And the months to come, we will see a lot more innovative application of NFTs. We don't look at the profits or loss of the metaverse. We look at the activities that it generates. How many people are building on it? How much employment is being created? To us, our goal is to build a shared network effect to help and grow and expand the ecosystem. By doing so, this will in turn obviously enrich Animoca in the process. So quickly, how can we share this for the Belt and Road? The metaverse is an increasingly important driving force for growth in the global economy. Having digital property ownership, non-fungible tokens will foster economic growth. It will open up opportunities and new market. It will facilitate inclusion and cooperation. The Belt and Road itself could be the platform in which people come together to build an ecosystem or to create a metaverse. And the effect of the shared effort is the creation of employment, additional source of income, new form of fundraising, joint experiences, and more importantly, unity between the countries to create a Belt and Road community. Thank you.
Thank you. Thank you, Jamie. Thanks very much. May I now invite Jonata to please make her presentation. She'll be doing it virtually.
Yeah, thank you so much for having me here. I wish that I was there in person with all of you, but Chicago is just a little far. But hopefully next time I will be there in person. Before I start, I did want to note that any views that I speak about today or that I express today are my own and don't necessarily reflect those of the American Bar Association or of my employer. So when it comes to privacy, security, and the metaverse, I'm sure all of you have heard an ounce of prevention is worth a pound of cure. So that's something that I would like to speak about today. So really why this is important is because the norms that are set early on, they define the culture of a space moving forward. And the norms that we decide on now will define the metaverse moving forward as well. In addition, it's much easier and cheaper to build with privacy by design from the start than try to bolt it on later. As we see more and more consumers become more interested and concerned about privacy, different platforms or companies that don't respect privacy may have a loss of adoption and a loss of customers, which can lead to a loss in revenue down the road. And lastly, a lack of respect for privacy can lead to the inability to do business in other jurisdictions, which will slow growth opportunities for people in the metaverse. A little bit of background, privacy versus data protection. So data protection focuses on protecting assets from unauthorized access, while data privacy defines who actually should have access to those assets. And data protection is mostly a technical control, while privacy is more of a process. So we see data protection as the mechanism, so the tools and the procedures that are used to enforce policy and regulation, while data privacy is the regulation or policies that governs the use of data by a particular entity. So why privacy? Why are we talking about privacy today? So privacy, we kind of call it a gateway right. So it's foundational to the exercise of other fundamental human rights. So for example, freedom of thought, consciousness, belief, association, and assembly, as well as the right to be free from discrimination. And the point of privacy is to allow us to figure out who we are, and it lets us explore space and figure out what our place is in that space without restriction. And privacy can support greater assembly in spaces, especially on controversial issues. So as we spoke about earlier, the metaverse is a multi-jurisdictional space. So it will affect multiple jurisdictions. So as somebody from the United States, I did want to impart some of the lessons that we ourselves have learned when doing business and how that relates to privacy. So here in the United States, we don't have a federal privacy law unless you're discussing children, healthcare, or finance. What we have here is a fragmented patchwork of privacy laws where you have a lot of states proposing and passing their own privacy laws. We call this the patchwork because they're all different, which makes compliance very difficult, costly, and time-consuming, as well as confusing both for businesses and for consumers. A lot of our privacy laws were written in a very hasty manner. So really the recommendation here is that privacy laws should be written with all stakeholders and experts at the table and should really take these issues into account. In addition, in the United States, generally, unless you are in certain states such as California, we have very few privacy rights, and we also have high government surveillance. So this really means that there's no adequacy decision from the European Union. So data transfers and compliance with data transfers is very, very high because you have to have contractual measures as well as technical measures versus when there's an adequacy decision, the country is adequate, you can just transfer data. So the cost of the transfers and the cost of compliance is so high that some companies just choose not to do business in the EU at all, leading to a large loss of potential revenue. Now, because of lack of regulations, I'm sure you all know the Cambridge Analytica scandal. So that led to a loss of customers, future and existing revenue, loss of trust, loss of future customers, fines, costly litigation, and importantly, calls for more stringent privacy legislation. In the European Union, we have very well thought out and comprehensive legislation, but there are some rules such as the cookie consent rules that have led to privacy and consent fatigue, where consumers no longer pay attention to what they're consenting to. And also lots of difficulty adapting to latest technologies, which kind of brings us to the chicken or the egg problem, which comes first, the technology or the law. There are other considerations that I wanted to bring up when it comes to the metaverse and privacy. Biometric data, such as retinal scans. Biometric data cannot be changed, so somebody cannot change their retinal scan. So they should be either subject to increased protections or not collected at all. Actions in the metaverse could reveal extremely personal information about an individual in the real world that can have real-world consequences. Children's privacy and parental consent, how does that factor into the metaverse and privacy protections? Health data, which is very sensitive data, so protecting that information from a privacy perspective and a security perspective. What rights would individuals have with regard to their privacy in the metaverse? How can we make sure that they participate in the metaverse and feel comfortable doing so and feel comfortable accessing the metaverse? What happens if privacy rights and safeguards are not included? Cybersecurity risks and bad actors. Who is data shared with, and who should it be shared with? Including government surveillance. Compliance with with laws in all jurisdictions. So compliance may need to become more standardized. We also need to make sure that international norms related to privacy, such as Article 17 of the International Covenant of Civil and Political Rights, are followed and complied with. What is the impact of privacy issues to non-users? So there will be non-users of the metaverse that are impacted by the metaverse, and how do we actually combine that and protect that? As well as augmented reality technology and the merging of AR and VR, which will really have a big impact on non-users as well. I do have some next steps that I would like everyone to think about, and I kind of parse these out by type. So governments and regulators, I think, should really talk about creative, proactive legislation that sufficiently covers and prepares for the privacy and security issues inherent in the metaverse. So really take sufficient time and thought and have all of the stakeholders involved in the process. And legislation should be created with the help of experts and all stakeholders, including consumers. So learning how this affects them and how we can make sure that they're comfortable. For companies, think about going beyond legislation to build trust with consumers. As consumers become more interested in their privacy, they do tend to choose companies that protect privacy over companies that don't. So caring about privacy can become a competitive advantage. Implement privacy by design principles and build with privacy in mind from the beginning, especially since we have an opportunity to do so here. Perform an assessment to fully understand the privacy and security risks of operating in the metaverse, and build transparency and practice informed consent. Trust is hard to build, but it's very easy to break. And if you build trust from the very beginning, that will lead to more adoption, brand loyalty, more customers, and more revenue. And for bar associations, raising awareness and understanding among the legal community of emerging privacy issues, and providing programming such as this that helps the legal community advise their clients on the issues with respect to the metaverse. This is definitely an emerging issue, and it's not something that's going away. And it's definitely something that you will need to advise your clients on in the future. So definitely make sure that the bar associations are preparing their attorneys for this. Thank you.
Thank you very much, Tanasha. Thank you very much. I'd just like to say that Mr. Duncan here had urgent matters to deal with, and therefore he had to leave. But fortunately, and thank you, Nick Chan has agreed to join the panel. And of course, he's a great contributor to innovation technology and also director of ALCO, which is the following session. But anyway, thank you for filling in. So let's move on. We have some questions already. Jamie, I think there's one for you, specifically for you. So are you okay with addressing that one?
Hi.
Do you want me to read it out? I'm not sure whether they can... is it available to everyone to see the question? Okay, Jamie, would you want to read it out, or shall I read it out for you? Okay. It says, hi, Jamie. If someone, I think they mean bought a Marvel comic which contains a code to redeem for a, Fortnite? X-Marvel collaboration skin, or on Fortnite, the code turns out to be defective, and both Epic Game and Marvel customer service keep sending you to their counterpart. The skin on the Fortnite account is not transferable. Is there any property ownership on the skin, or just by ownership, the redemption code itself? So very technical.
I think, I mean, I'm not familiar with the Marvel games, but my guess is that is a Web 2 game. And so the distinction between a Web 2 and a Web 3 game is Web 3 game exists on the blockchain. And so by definition, if you were to buy a skin, which is basically an NFT on the blockchain, you own that NFT. So, you know, one of my limb that I wanted to talk to you about today is interoperability, but I don't have enough time, so I cut it out. So basically, that means that you can actually take that skin out of the game and use it on a different game. But, you know, for Web 2 games, you don't actually own the skin. You're basically renting it. So the Web 2 companies own it, and you may have paid for it in the game thinking that you owned it, but that's not the case for Web 2 games. That is only possible if it's a blockchain game and what you're buying, as in the skin, is an NFT. So that will actually exist in your wallet, and that will allow you to take it out. And even if the game, for whatever reason, stopped developing, you still own that skin, and you later on can take that skin and use it for another game. And one of the things Animoca Brands have been doing with other companies is we've formed an Open Metaverse Alliance, which will think about how to set standards for interoperability between various different platforms.
Yeah, actually, that segues in very nicely with what I was going to say. But Nick, yep.
I'm an investor in Epic Games.
Right.
But I would say, I mean, it's a very good question, highlighted the point, interoperability. Jamie is saying, essentially, under the present system of many platforms, potentially, I'm not saying this particular Fortnite game, but potentially people just have a contract. Players just have a contract with that platform or for that particular game.
Yes.
And they don't have direct license with Marvel. Yeah. So they might not be, you know, the right party to go after Marvel. Maybe we should talk about third-party rights, right, which exists in some laws,
yes,
jurisdictions. But ultimately, once you move on to the open first vision of Animoca Brands, as I understand, things are interoperable. You can move them around.
Yeah,
thank you.
That's, as I said, leading, Jamie. And also, Janata is assets. You were talking about ownership of assets and talk about security. Web3, Jamie, you're quite right, goes into blockchain, so they're secure. But isn't there a need to sort of have unification? Because we're not talking about a physical jurisdiction. We're talking about a virtual jurisdiction which doesn't exist, but no laws cover its existence. Right? Is there a law that governs the existence of virtual assets, etc., universally? There isn't one. How do we get to that? The only way to get to it and to protect it would be through blockchain. And then when we have blockchain, do we then have international registries? If we have international registries of assets, could we then allow financial development of that because it's registered against a particular person, transferable? And then you talk about, Jamie, interoperability and what laws do we have to restrict interoperability if you have, and also Donata's point on security. So any comments on the unification of systems or laws or systems that enable laws to be developed? So Jamie first.
I'll go first. So we were having a discussion with some of the delegates before that my personal view is that, you know, we regulators and Web3, you need to sort of strike a balance of what to regulate. The attraction of Web3 is that it is decentralized. but obviously issues will come up, disputes, and how do you regulate those? At the moment, how we view it is that, with NFTs, it often comes with a license agreement. And within the license agreement, it will set out the governing law. So it's not too different from real life in the respect that there is always some sort of terms and conditions that apply on the platform with regard to your use of the platform or with regard to your NFT. And that of itself governs the relationship between the issuer or the creator and the people that buys it. And usually we would have some sort of mechanism that govern your rights and obligations under it. So one of the things Animoca Brands is trying to release at the moment is a open source terms and conditions in relation to NFTs, which sets out the rights and obligations of a holder. And we hope that this term and conditions will be adopted by different creators, which allow us a uniform T's and C's in the market. And it also will standardize what people can or can't do with their NFTs, such as one of the hottest topic at the moment is circumvention of royalty payments to the creators.
Yeah, exactly. Nick, do you want to...
Sure. Well, we always say, right, the law in the physical realm applies equally in the virtual digital space. But to the extent, whether there is a specific law tailored for the metaverse is to be discussed. And but I guess to answer your question, it's a combination of players, stakeholders in the market. When they see a soon $3 trillion market metaverse, do they want to break it? Do they want to build it together? As lawmakers in the room, our friends here, what do we want to do? Lawyers, do we want to propose something that is super protective, but at the same time stifles its growth, or it's a combination? So if you have, I think it's a combination. You have the smart contracts that deal with it, and just like in the real world, as we do today, how do we protect the small companies? How do we protect the small consumers? If the brands themselves, the companies themselves, stakeholders are being fair, then we might not need to over-regulate too much. Thank you.
Thank you. Janata, specific aspects to what you said earlier.
I think that we have a very fundamental issue, which is informed consent. I think as attorneys, we can write terms of service, we can write contracts, we can do all of that. But until consumers understand those, they will always feel cheated by, these agreements. Because in this person's example, they buy a skin, but they didn't know that it's non-transferable. Well, if we told them that it's non-transferable, would the issue still be there? And I think that that's something that we do need to work on when it comes to the metaverse, is writing these agreements in a way that can be understood by most consumers, and then they can actually give informed consent and know what they're signing up for.
Yes. We all know the concept of confidentiality and informed consent, but it is interesting. It's also interesting. Nick, sorry,
I was going to add a point. In metaverse, in digital space, people often want to walk around in their avatar. They don't want to be themselves. They want to be anonymous. So if you were to have law, who do you apply it to? Does it lead all the way to a real name system? Or do you have ways so that you could, at least secure the necessary digital wallet to enforce against? Do you have a central registry? Do you have DAOs? There are plenty of ways to, to put it together, I think.
Yes.
And so I think friends from the Belt and Road jurisdictions, as we come together, we could explore this and how to build this into a better place.
Jamie, on interoperability, just from your experience, you've got some element of experience on interoperability, at least one or two contracts where it can be interoperable. So give us your experience on how interoperability could work, since you already have sort of sharing of, say, transfer of contracts or transfer of whatever they've signed on to on Web3. Just share with us your experience.
I don't think at the moment there is a standard or how we think the regulation in terms of interoperability, because what we're trying to do is not so much allow interoperability between subsidiaries of ours. We're trying to expand it so that it applies generally to all Web3 companies. And by doing that, we need to still consider further how is it that we allow interoperability? Because if an issue comes, because all the companies are globally, which jurisdiction will apply, which law will make the most sense? And that we haven't yet come to a conclusion, but that's something that we need to do. At the moment, it's fairly easy because between our own subsidiaries, we can obviously manage that. But when we're trying to broaden that, that would be something we need to tackle as well.
Yeah. That goes to law. If, as I said, it's a blank sheet, what we write is what we get. So we don't have any laws. Hong Kong could actually introduce laws with the focus that others like Animoco wants to look at laws that exist. So we create laws which attract companies to use this law as a basis for their contracts is one way that legislators could work towards development of law before law is required. Usually we have development of a product and the law follows that. Here we could think about a law and products then follow it, a bit like our Principle 1.07 to the Guide to Professional Conduct, the concept of it. So what do you think of that, Donaja? Because you've got specific issues on privacy and human rights elements on that.
Yeah, I think it needs to be standardized. So if there is a law that's written that is, way different from GDPR, or way different from Pipetta or whatever, you're not going to be able to do business across different jurisdictions. But if we standardize it and follow a similar set of principles, it's going to make compliance significantly easier. So somebody who manages over 10,000 privacy policies, whenever there's a jurisdiction that passes a law that's significantly different from others, that makes compliance very, very difficult. And it makes data transfers very difficult. It makes, working in different jurisdictions very difficult, and makes doing business in different jurisdictions difficult. Because if we think that we're going to build a metaverse that's self-contained and somebody from the European Union or the United Kingdom is just not going to be allowed in, we're going to lose a lot of revenue and we're going to lose a lot of users. So to me, creating a law first starts off with getting everyone at the same table, whether that's from the consumer side, from the game developer side, from the NFT side, from the metaverse side, from, professors. Everyone has to be there at the table, and every issue needs to be discussed.
Nick?
I think I get your point. If we have a law that's called the Metaverse Law, or the encouragement and fostering of Metaverse Law, I think that's sexy. I think that's useful for the world to, really think about, leveraging on Hong Kong as an international center, international city to deal with this. On the point raised by a friend from America, I guess if you have different states with different data privacy law, partly is because of how your constitution is structured, right? And partly because, big online platforms are congregated in certain western parts of your country, and they have certain lobbying powers. But in Hong Kong, we have to get familiar. I mean, lawyers here are very familiar with GDPR for EU, also the PIPL, which is not just 4% but 5%. Potential penalty on turnover. So we are in a good place to contribute, I think. And following on the point made, I think if we come up with a certain base of standard, so the laws are interoperable because they harmonize in that sense, and platforms are open. It's not just a metaverse, and as Yatsu always mentioned, it's an open verse, right? So everyone's together. So I think there's a lot we could do together.
Yeah. I think the other suggestion would be that you could have a convention, metaverse convention, and because it's very difficult to get agreement, perhaps we follow the other conventions and have opt-out provisions within the convention. So certain countries can say, we don't want those provisions to apply, but of course that doesn't exclude others. So Animoco, for instance, can say, well, we'll create a virtual reality, whereby in this virtual reality one, GDPR doesn't apply, and those who opt out for that go to virtual reality 1. And that allows things to progress without actually having to wait for full agreement across the globe, as it were, or the virtual world. So maybe that's something that, Jamie, what do you think of that suggestion?
I think that's a great suggestion because, as I mentioned earlier, it's, we need to strike a balance which allows, still encourage this industry, the Web2, to continue to grow and not restrict or hamper it by too much regulations. So if there are different types of metaverse where people can opt in depending on how they wish to operate their platform, I think that is a possible way to go.
Yeah, allows us to progress anyway. So let's see if we can look at another question. It says, will the metaverse face the same kind of risk as cryptocurrency? What kind of measures can the authorities and or stakeholders adopt, propose to prevent crashes similar to the subprime debacle, as these virtual products do not have a tangible real asset backing? Nick, do you want to take that?
Sure, I'll go first. Well, I think, I've had friends who, sort of looked at the white paper and bought some cryptocurrency and waiting for, NFT coin tokens to drop to your digital wallet. And after it's minted, it doesn't drop at the same time as it should be. So that technically you're supposed to get one unique, token now with a link to a particular virtual asset, but it didn't arrive on day one for technical errors, glitch. So what do? Who do you go after? Because the nature of cryptocurrency or NFT using cryptography, they're limited in numbers. Yeah. So if it didn't go to you, went to someone else, where do we steal it? Where do we give another one? There's no central party that could do it. So one of the ways it's been discussed by the DOJ's mediation conference earlier is that we together we share some points. I just want to share this again here. So if there are systems people have put in place to try to address this, not by way of law, but by way of process and contract. Yeah. So if there's a dispute between people in the same ecosystem, in the same coin, if cryptocurrency, if it didn't work out as planned, let's go with what we do on the metaverse, digital space. Let's vote online. Each token you're allowed to put one vote. You could stake it. You could put money out. So if I dispute against Jamie over something, we're supposed to have transferred this. It didn't happen. Let's let people in the room who have this token have the word. They decide. So if more than 50% of people decide that Jamie's right, and of course that's always the case, then those who are right, to vote on it, you have to give up stake up a token. And if Jamie wins, you sided with Jamie, you also win something. You sided with me, you lose something. So at least there's a way to squeeze something out to share, to solve some of those disputes.
Yeah, democratization,
yes.
And
yes.
monetization.
Thank you.
It's an excellent example.
Thank you.
Janat, did you want to add to Nick's, develop on Nick's aspect from security policies?
So I definitely like his approach. I think to take it in a little bit of a different vein, when cryptocurrency first came out, it had very low adoption rates, at least amongst the general public, very low. And that was because of a lack of trust. And this isn't necessarily related, but one of the first privacy laws in the United States was the California Online Privacy and Protection Act. And the sole reason for passing that privacy law was to build trust in consumers so that they could purchase online. And I think we can learn from that because, when it comes to the metaverse, if it's not regulated at all, we're also going to have a very low adoption rate, at least at the very beginning, just like we did with cryptocurrency. So I think we have to reach that kind of Goldilocks zone here where it is regulated, but it's not regulated too much to the point where it does stifle innovation, but it's regulated to the point where consumers feel comfortable there. I think that will lead to higher adoption rates.
Thank you. Jamie, I'll let you comment because you must be dealing with cryptocurrency.
Just to Nick's point, there are decentralized arbitration platform, which basically works in very similar ways that you've described. So it is out there. Adoption rate is not very high, but it's there. And I do see it moving more towards decentralized arbitration as a way we can think about doing things that govern disputes in the metaverse later on. But just going back to the question, what you're talking about really touches upon securities law. And every day, part of my role is determine whether tokens are securities or not. Yes. Obviously, if the security is used for pure utility, which most of them are, there is no such thing as backing by stable coins or fiat, because the point of buying the tokens in the first place is not an investment, right? You're buying it for, like was Duncan mentioned before, either access to membership, or you want to use it for access to games, or you want to be able to have the utility for voting purpose, or also to be entitled to like future drops of skins or weapons, etc. Those are utility tokens, and those, by definition, is not security and should not be required for any form of backing. But of course, there are other tokens which most shouldn't be, a borderline security. And that's definitely an area that needs to be regulated, and that I agree. And I think there is a lot more regulations that needs to come out in all countries in the world, including the United States, is what is considered as security. And at the moment, the SECs in the US have taken actions against a lot of these tokens, claiming that they are security, without offering any clear guidance as to what would fall within the security and what wouldn't. And so in this particular area, I do think regulation should come out, and I think more of it should make it clearer to Web3 companies, so that when they issue tokens, they know what it is, because sometimes they tread into waters that they do not intend to, and then they get pulled up by the regulators.
I think that's another key issue for development. Countries, authorities need to, again, create laws which allow for investment. So crowdfunding, for instance, right? Are we going to have it as a financial product, or can it be financial product if it's over a certain limit? 10 million, 20 million, 100 million, that's financial product. Below that, it's not, with carve-outs, with certain provisions. That will allow the product to be developed, but also not necessarily have to go into a financial product, and therefore securities issues that involve, which smaller companies cannot deal with, and therefore stifle development, as Donato was saying. What do you think of that? But looking at laws, looking at policies that create laws for development of these issues. Yeah.
Sure. I mean, laws are often about protecting the weaker people, the consumers. So just like in the US with the Jobs Act, they make it easier for smaller companies or smaller investments to happen. Just want to touch on the earlier point with resolving disputes. We have, Hong Kong's a great law tech center, and EBRAM Chairman Thomas, our past president, is in the room. So they have a really good system. I would, resolve my cryptocurrency problems through them.
Yeah. Well, that's what I'm saying. EBRAM has a platform which is ideal for development of metaverse virtual arbitration issues, which they could develop before it even exists, and therefore, again, blue ocean strategy.
Yes. But I would say I agree with Jamie entirely. We should have some laws that address it, because with a $3 trillion market upcoming, people, we want to find a home for it, a domicile, legally speaking, a domicile for the company to operate. And you can see this, what, $4 billion? What is your valuation now, Jamie? Company? You're allowed to say? $6 billion valuation.
Yeah.
And their home is pretty much in Hong Kong, right? Yes. So, it's not by accident. Partly, but it's not entirely
by innovation.
By innovation and with the right people. Yeah. So I think it's a right place to do it, and we can't do it alone, right? We have to work with our friends from all over the Belt and Road, pass the right laws, do the right thing, harmonize our laws.
I'm just trying to see. I've got another one. Question says, what is the role of PRC about the development? That's from a question slip. Not sure, Nick, do you want to say that? Yeah.
So in the mainland, they haven't passed a specific law on the metaverse, but I understand about 10 provinces have passed specific measures to foster the growth of the metaverse. So I hope that partly answers the question.
Yeah.
Thank you.
Just trying to see whether we have enough time. Another question is, what are the potentials and challenges of developing metaverse, especially along the Belt and Road, from the legal perspective? I think we've covered this. So I think Duncan said it's a bit difficult when I said along the Belt and Road, when metaverse doesn't exist along the Belt and Road. But ultimately, if you were to bring the metaverse back into the physical plane, then you'd have the marine road and the belt and the land belt, as well as now.
I'm wondering, maybe on their sandbox we could have a digital twin of our Belt and Road countries. You put out the map, but we should, maybe you already have that, but maybe you have a particular theme on the Belt and Road, and we can not only come here together today physically and virtually, but also every day virtually on, the Belt and Road.
Absolutely, yeah.
Yeah.
I'm going to end by asking each of you. Jamie, I'll go first. What do you think about the use of avatars as identities?
I talk about this from a personal point of view because I'm very much into the NFT community. I love it because it allows me, and that's actually the main attraction and how my passion grew. Because, as I mentioned before, using an avatar basically allows open communication. So I would be in Discord and I would be talking to people globally. You don't know their race, you don't know their sex, you don't know what profession they are, and you don't know what gender they are even. And the fact is everyone come onto the same platform and they talk to each other, share information, they share knowledge, they help each other out. And I absolutely love that because if there is, and you find through conversation that you realize, oh, this person's only a 16-year-old teenager,
yes,
but is so knowledgeable on crypto, or this person's a mother with four children, but yet, very passionate about NFT. But without them telling that on the Discord, you would not know that. And then you talk to them as if, your buddy on the street or somebody or someone in your office. And that allows a lot of openness, and that's, I think, using an avatar is a great idea. And although I said it obscures identity, which creates legal problems, but it also, the advantage is it allows and facilitate communication.
Thank you, Jamie. Nick?
Like the movie Transcendence.
Yes.
So we download our consciousness into not just one, but multiple avatar twins or triplets. Lawyers could bill more than quite a number of hours a day, I think. So that would be my avatar, I think.
Yes.
Thank you.
What do you think about the avatar?
So I really see it as the holy grail of privacy, right? As long as that information cannot be tied back to a physical person in any way, you can be whoever you want to be. You can be yourself, you can express your feelings, express your views without it ever coming back to you in person, which I think is really, the epitome of what we seek as privacy professionals. And I think when it comes to the metaverse, we have to protect that, and we have to protect that ability, because as soon as somebody creates an avatar and then all of a sudden they are identifiable as that particular person, all of that kind of falls to the ground and we lose that trust. And I really think it's something great that should be protected.
Yes. So thank you very much. That's been a very healthy discussion. I'm sure we can go away and add further to its development. So I'd like to thank the speakers. Thank you, Jamie. Thank you, Nick. Thank you, Jonathan. Thank you, Duncan.
So thank you very much. So just now, today we have an audience of over 1,400. And this audience has just listened to our on-site speaker, Mr. Amrali Nasir, MXJP Vice President and Chairman of the Innotech Committee of the Law Society of Hong Kong, the Honorable Duncan Chiu, Member Technology and Innovation Legislative Council of the Hong Kong Special Administrative Region of the People's Republic of China, Ms. Jamie Kwok, Head of Legal, Amimoca Brands Limited, and And physically, we also have Mr. Nick Chan, MHJP, Director of Asian African Legal Consultative Organization, ALCO, Hong Kong Regional Arbitration Center, and online from Ms. Donaka Stronic-Skilrod, CIPP on virtual. She is the president of Termagadon LLC. So I'm sure this audience has taken a lot for food for thought and takeaways. So now may I invite Mr. Nasir to present a souvenir to the speakers as a token of appreciation and to take a group photo. Mr. Nasir, please. Okay, so before we formally end our session one, just now our speakers talked about eBram. So actually, for our guests who are on site today, may I introduce to you, we do have an eBram counter outside our conference room out here, and it is called eBram. We have the Hong Kong Legal Cloud Portal. This is developed by eBram and launched on the 1st of March 2022. And this is the first cloud in Hong Kong tailored to the unique needs of the legal and dispute resolution communities, particularly those who work in micro, small, and medium-sized law firms, to assist them in enhancing efficiency by offering them secure and affordable data storage and fair online law services. So the Hong Kong Department of Justice has subsidized eligible legal and dispute resolution professionals in Hong Kong to use the portal for a period of up to 3 years. So for the key features, whether you are eligible or not, please feel free during the break time to know more from the counter outside. So now, I declare that this session one formally ends here, and for now we will take a 15 minutes break, moving on to session two. So for guests online, participants online, again, there is no need to log out, and we will come back in about 15 minutes. So see you again shortly.